Recently, Alabama has been under fire for the system it uses to sentence people to the death penalty. In Alabama and other states that still have the death penalty, the only crime punishable by death is capital murder. So what elevates a crime to capital murder? Well, any murder that's considered premeditated usually qualifies as capital murder, but there are a number of things that can elevate murders that weren't planned to capital murder. These are called aggravating circumstances. For example, if someone goes in to rob a gas station and only planned a robbery, but during the course of the crime they get recognized and make the spur-of-the-moment decision to kill someone to hide their involvement, that's also capital murder. Even though they didn't plan a murder, it happened during the course of another felony, making it a capital murder. And there are other factors that elevate unplanned killings to capital murders. Killing multiple people or children or negligently creating a situation that could lead to death without regard for the danger can all lead to capital murder convictions. But juries also have to look at mitigating circumstances. Those include things like whether the defendant was under the control of another person, whether they are unable to understand the consequences of the crime, if they are under the age of 18, or if they do not have any significant criminal history. During deliberations, a jury looks at the aggravating and mitigating circumstances and determines whether or not to convict for capital murder. None of that is where the controversy is. The controversy is that in Alabama, after a jury convicts someone of capital murder, they then make a recommendation to the judge for a sentence of life in prison or the death penalty. But it's only a recommendation. The judge can ignore a jury's recommendation of life in prison and sentence a defendant to death. And it's not that uncommon. In the last 35 years, Alabama judges have given death sentences to defendants where the jury recommended life in prison over 100 times. That controversy grew in early 2016 when the U.S. Supreme Court ruled that a similar death sentencing system in Florida was unconstitutional. In that case, the High Court ruled that because of the task of weighing aggravating and mitigating circumstances to arrive at a death sentence fell on a judge and not the jury, it violated the Sixth Amendment right to a trial by jury. After that ruling, Florida was forced to change their death penalty system and Delaware changed theirs, leaving Alabama the only state that still allows judges to give the death penalty after a jury voted for life in prison. Alabama's system has been challenged, but on September 30th, 2016, the Alabama Supreme Court upheld the system as constitutional. They determined that the aggravating and mitigating circumstances have already been weighed by the jury when they voted to convict a defendant of capital murder. So the judge isn't deciding whether the crime is eligible for capital punishment. That was already done by the jury. The judge is just determining the sentence. So is there any chance that Alabama will change its system? Well, there probably isn't enough political pressure for Alabama lawmakers to voluntarily change the criminal code. So if it's going to change, it will likely require a U.S. Supreme Court decision like what happened in Florida. And that's more or less the current state of the debate over capital punishment in Alabama. I'm Jonathan Sobolewski for AL.com.